They don't need to see all of the intricate components within that trust document because they are authorized to adhere to the actions of the trustee via that separate document I mentioned first, which was the trust certification. That's essentially the get out of jail free card, if you will, for the bank. Okay. Dr. Winshen asks, in opening a bank account under the officer name as manager, it asks for the percentage of ownership. Do I put 0% or 100%? And then further, she asks, if I put 0, then it asks for beneficial owners, meaning it would be the trusts in this case if we're talking about a holding company likely. Do I put the trust information as a 50% ownership? If the trust, then it asks for personal information and Social Security. So do I put my personal information? Well, first and foremost, Dr. Winshen, that is an excellent question. I'm actually pretty excited about it because this leads into a discussion that I'm going to basically say to each and every member of our community, be sure to be on the lookout because coming in the next couple of weeks, we're going to host a wealth wisdom workshop on finance and banking, right? So I'm going to be talking about this in greater detail than I'm going to answer in this particular response. But again, I don't want to gatekeep. I want to give you at least a very high level perspective into the process of opening bank accounts and what information is going to be needed. Let me start off by saying this. Every single financial institution is going to be bound by two things. First, they're bound by federal regulations, meaning if they're part of the FDIC, they are required to adhere to federal requirements with regard to opening financial accounts. The second thing they are bound by are their own policies and procedures. So with that being said, Bank A and Bank B can have very different processes for opening bank accounts. So going to Bank A, you may be required to do X, Y, and Z, whereas going to Bank B, you have to do D, E, and F, right? So with that, again, I just want to make sure I'm very clear. That's a lot of frustrations that I see business owners experience when opening their bank accounts in order to fulfill on the operational component of the Real Wealth Matrix. They get frustrated because they may go to a bank and the bank creates a lot of friction with regard to that opening process, that bank opening process. Each of the separate hierarchies of ownership in your Real Wealth Matrix are ripe for having their own respective financial accounts. With that being said, the trust hierarchy can have its own financial accounts. The holding company hierarchy can have its own financial accounts. The operating hierarchy can have its own financial accounts. Most financial institutions will require a few basic things. Thing number one is proof of who the owner of the account is going to be. That is going to depend on what hierarchy we're talking about. If you're talking about the trust hierarchy, the type of proof that is going to be needed is something called a trust certification. That is a document that stipulates that this trust exists and that this trustee is the authorized party to engage in activity for that trust. Oftentimes, many banks will like to see the trust itself as well. However, what I teach our community to do is to not give the bank your actual trust document itself, not at least in its entirety. Why? Because the trust is a private agreement. I don't want the world to know what's written in that document. But the bank will want to make sure that this trust is a legitimate trust. So the way I suggest individuals engage with regard to that opening environment is to have the front page and the signature pages of the trust available for the bank to inspect. They don't need to see all of the intricate components within that trust document because they are authorized to adhere to the actions of the trustee via that separate document I mentioned first, which was the trust certification. That's essentially the get out of jail free card, if you will, for the bank. If they open a bank account on behalf of the trust, they're not going to be held liable if there was some malfeasance happening. That trust certification is the authority, if you will, that the bank will rely upon. Now, You, as the trustee, which is what's going to happen in most circumstances, right? Because we're talking about a grantor trust, a revocable trust. You, as the trustee, also have to prove who you are, right? So you're going to need a government-issued photo ID that is valid. That does not negate anonymity. The bank itself is required to hold your personal information in confidence. They're not permitted to disclose this to third parties, with the exception of FinCEN and any reporting agency that that particular bank reports to. But even that disclosure is not public disclosure. Right. That typically becomes the biggest question I get. Like, if I'm giving my bank my personal information, does it negate all the work I've done in order to create the anonymity in the first place? The simple answer to that is no. It does not negate anonymity. All of the information you provide to the financial institution is held in confidence. I simply don't want to give them the entirety of the trust because I don't want the banker to know all my personal details, right? I don't want them to know the intricate components of how I've decided to structure assets for the benefit of those that I care about within the context of a trust. Okay, so that's step number one. Step number two is they may wish to have proof of location, right? So that's typically supported by your government-issued ID, right? Your address information is likely going to be printed in that. If it is not printed on the government-issued ID, an example would be a passport, your personal address is not printed there, well, then you may wish to support it with like a utility bill that has your name on it, something of that nature, right? That's typically what's going to be required at the trust level, because the trust financial accounts are considered personal accounts. They're not business accounts. Now, there could be a way that you establish, because certain financial institutions won't actually create a trust account with the title trust in the account name. They may wish you to create that particular financial account sort of like a sole proprietorship account, right? So as an individual in a sole proprietorship capacity, even though the trust is not really a business, right? Certain financial institutions just use different methodologies by which to open those respective accounts. At the holding company level, well, the owners of the holding company are the trusts above. So that financial institution is going to request information regarding the owner. Well, we've just done that when we established the trust bank accounts, right? The first page and the signature pages of the trust, plus the trust certification, plus your identification information, right? With regard to the holding company, though, that is a business entity, so the bank will also want proof of the business formation. That's going to be something referred to as your articles of organization, if we're talking about an LLC, or articles of incorporation, if we're talking about a C corporation, right? So that additional information is going to be what the bank is going to require. Now, the operating company, very similar, but the member there is the holding company above. So you're going to need the information regarding the articles of organization for the holding company. Again, your proof, if you will, of your own personal identification information. And then the articles of organization for the operating company, or articles of incorporation if it's a C Corp. Now, again, within the context of the holding company and the operating company, an additional resource that I often advocate for is some formal notice from the company to authorize you as an individual to open a financial account. Sometimes this is referred to as a corporate resolution, which is simply a document that states that XYZ LLC authorizes Joe Sample to open a financial account on its behalf. Some ways that you can enhance the interpretation of authority from that financial institution is at the company level, adopt within your operating agreements officer titles, right? Adopt the ability to appoint yourself as an officer of that entity. While LLCs, limited liability companies, by statute do not have officer roles like president, vice president, treasurer, secretary. By statute, LLCs do not have them, but that does not say you cannot have them. Your operating agreement can stipulate you would have an officer as a member, if you will, of the officer role in that particular LLC. So you can name yourself, as an example, president of that LLC, even though, again, the officer role isn't something that's incorporated in a statute under the LLC. You can still create it through the operating agreement. When you do that, if your title is president, there's this deemed authority that the president has the ability to act on behalf of the entity, right? The president can open a financial account. I still advocate for you to use something called a corporate resolution. So now that is the framework. Now there's a lot more detail that goes into financial accounts and establishing them, but that's the framework. So now let's address Dr. Winston's question more pointedly. Who do you list and how do you list the person opening the account? At the trust level, I'm going to list that person as trustee. Why? Because I don't want my personal name in my personal capacity to be associated with that account. At the holding company level, I'm typically going to list it as an officer, meaning president of the holding company. Sometimes I may list it as a manager of the holding company, but that's where the corporate resolution becomes more important and more challenging. At the operating company, again, I'm going to list it as an officer, president of the operating company. But again, I could be named as the manager and authorized as such by that corporate resolution to open the financial account. Now, many financial institutions have started to adopt language that complies with the Corporate Transparency Act. If you have not yet jumped into the training on the Corporate Transparency Act, specifically the second module, which is the most recent module in that training course, I talk about how the Corporate Transparency Act is something that most business owners should be following and filing their beneficial ownership information form, the BOI form, even though it was ruled as unconstitutional by the Federal District Court of Alabama. Even though it has been ruled as unconstitutional, it is still in force for everyone who was not a plaintiff in that particular lawsuit that went before the Federal District Court of Alabama. So while it's still in force, I'm going to suggest that you continue to carry forward with it. With that as the backdrop, the Corporate Transparency Act refers to something called a beneficial owner. So many financial institutions are also now collecting that information. So if you are listing someone who is opening the account that is not an owner, meaning you're not specifically calling them out as owner, for instance, if you're calling yourself out as the president or you're calling yourself out as the manager, the bank may, again, depending on the financial institution, may ask you to complete beneficial ownership information. Again, completing that type of information does not negate anonymity. All of that information is required to be held in confidence, secured away from public inspection. So again, I want to make sure that you understand that continuing down the realm of creating these financial accounts does not put you into any muddy water with regard to everything else that we talk about here inside of the UpLevel community, specifically with regard to the utilization and the establishment of your own personal real wealth matrix. If you're interested in learning more about the topic of trust planning, I put together an entire program, an entire course inside of my private community that goes over all the details. If you're interested in taking your life and business to the next level, go ahead and follow the link that's in the description below.